Picture the Senate chamber floor, its marble echoing as a reporter's question cuts the air. Is the White House truly considering suspending habeas corpus? The advisor pauses, leans toward the microphone, and answers with one word: perhaps. Around the country, headlines swell with another word: invasion. Why would a republic use the language of war against unarmed migrants? Something vital rests behind that choice of words, and it is larger than the border itself. Imagine the briefing room in Washington, where Homeland Security Secretary Kristi Noem tells Congress that immigration numbers meet the threshold for suspension under the suspension clause of Article 1. The clause speaks of rebellion or invasion. Courts, from New York to Texas, have long said those words mean armed conflict. Yet now the debate rises again, as if echoes of cannon fire drifted back from the deserts of Arizona. The administration claims safety requires such reach, but law, once bent by fear, rarely straightens by itself. The question that stands unanswered is simple. Who holds the power to silence the judge's door, the President or the People's Congress? The answer waits farther back than this week's debate, in the heart of the Constitution itself. In the parchment lines of that document, the framers placed the suspension clause not among a president's powers, but among the legislature's. The privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion, the public safety may require it. They placed it there because they had seen what happens when one man decides alone whom the law may touch. Even in my own time, when rebellion broke the Union's bones, I felt the peril of that choice. Picture the candlelight of the War Department in 1861, papers stacked high, telegraphs clattering with reports from Baltimore. Arrests had been made without trial. Chief Justice Taney ruled I had no right to do so. I argued the nation might perish before Congress could meet, yet I also sought their later approval, for no republic lives long where necessity rides above law. And so we meet again this old contradiction. Must liberty shrink so safety may grow? Each age answers, and each risks error. To call migration an invasion alters more than policy. It changes the very compass of the Constitution. The founders used that word for armies bearing flags, not families carrying hope. If mere numbers can trigger wartime authority, then any crowd may justify a crown. Can a single phrase, uttered in haste, give one branch what 2 centuries of restraint denied? History whispers its reply. Think of the courtroom in New York, where Judge Ramirez faced lawyers naming the Alien Enemies Act of 1798, demanding swift deportations of Venezuelans tied, allegedly, to Tren de Aragua. 140 people, baker, driver, nurse, caught in a word's shadow: enemy. The judge asked for proof that Venezuela commanded their acts. The evidence was wanting. Still the machinery of state had stirred as if war had been declared. There, in that room, the Constitution itself seemed to breathe, quiet, steady, resisting the fever of the hour. Such scenes repeat through history, for power ever seeks its own permission, and conscience must ever pull it back. When fear names its object, courage must name its limits. During World War II, Hawaii lived under martial law. Courts later ruled the soldiers had stayed too long at their posts of authority. After the towers fell in 2001, new tribunals were built beyond our shores. Yet in Boumediene versus Bush, the Supreme Court said even men held far away could still ask, "Why am I imprisoned?" Liberty spoke through law, not through arms. The rhythm repeats: crisis, power, regret, reform. What lesson hides in that pattern that we still resist seeing? Imagine the Supreme Court steps this last May 16th, its columns pale against a rain-soaked sky, as clerks deliver the order freezing deportations. Cameras flash. Each lens seeks the face of certainty. But the truth behind those lenses is murk. Does safety or sovereignty guide us now? Step inside those marble halls, and you find not warriors but words. Every justice wrestles the same phantom. How much fear may a free people endure before they surrender the right to question power? The temptation is timeless, and the cure always the same: reason steadied by humility. From the frontier forts of 1812 to detention centers along the Rio Grande today, the Republic's test has not changed. It is the trial of self-command. Can a nation protect itself without poisoning its freedom? Law, like faith, proves its worth under strain. When government restrains itself, even while afraid, it earns its strength. The framers trusted no man's emotions, only his oaths. That is why Congress, not the President, holds the key to the nation's prison doors. If that key can be seized by one executive voice, then every liberty becomes a loan due upon demand. Picture a future courtroom where a citizen, not an immigrant, begs a judge for the same writ, and hears no answer because precedent has fallen silent. Yet here lies hope. Every time the people awake to such danger, they draw the reins tighter. After internment came apology. After secret claims of power came oversight and law. The pendulum, though reckless, swings back toward balance because ordinary hearts still know the feeling of justice. They sense when rhetoric turns sour, when safety becomes a mask for dominance. It is in those quiet recognitions, by jurors, voters, teachers, that the Constitution finds breath anew. Now think of a small hearing room in Phoenix, where a public defender lifts the worn pocket Constitution and reads aloud, "The privilege of the writ of habeas corpus." The client beside him listens through an interpreter, eyes wide but calm. No parade, no gunfire, yet the struggle for liberty is as real there as at Fort McHenry or Gettysburg. Picture the fluorescent lights, the flag in the corner, the clerk noting each word. The defender's voice does not shake. He knows that in this small room the question of power meets the measure of mercy, and that both hang on whether a judge may still ask why. Every generation faces this same whisper of temptation, to trade doubt for decree, patience for punishment. The louder the fear, the easier the bargain seems. But freedom has never been a gift kept by force. It endures because each citizen refuses to call fear by another name and crown it necessity. The founders did not make government's task easy. They placed chains upon authority because they remembered the stout links of tyranny. They knew that war words, once spoken, invite war deeds. To speak of invasion where no army stands is to teach the law to misread its own heart. If a leader may suspend courts for comfort, then soon he may move mountains for applause. Laws die not from sudden blows, but from small permissions. Think again of that Phoenix defender. When the hearing ends, he leaves into the hot evening air, crossing the street past protest signs and cameras. He returns to his car, drives home, and wonders if anyone outside that room will ever know what liberty looked like that day. It looked small, only 2 people and a book, but it was alive. The strength of a republic is measured not in noise, but in conscience. And so the old question comes again. How shall a free people remain secure without surrendering the soul of their freedom? My answer, as before, rests in law and in trust. The Constitution is not a garment to be torn when the weather changes. It is the thread that holds the nation together through every storm. When leaders hold fast to its limits, and citizens still demand reason instead of fear, the future stands open before them. The Republic can be saved. When the next voice tells you safety requires silence, what will your answer be?